Welcome to Wheat Hall, a countryside manor converted into a weekend getaway. Meet Jeremy, the owner and host. Jeremy is the occupier, a person with enough control over premises to owe a legal duty of care. Under the Occupiers Liability Act 1957, that duty extends to lawful visitors like these guests. Jeremy must take reasonable steps to make sure they're safe. But this old manor might not be as charming as it looks. Tina, one of the guests, is heading upstairs. Under the banister is dangerously loose. The banister gives way. She falls and is injured. The law says Jeremy owes Tina a common duty of care, including maintaining the premises or warning about risks he knows or should know about. This failure could make him legally liable for Tina's injuries. 14-year-old Leo is taking a shortcut home across the property. He's using a path the local kids often use, but Jeremy's fence is broken and there's no real barrier to keep trespassers out. Leo stumbles into a hidden ditch and gets hurt. He wasn't invited, so he's a trespasser. But under the Occupiers Liability Act 1984, Jeremy might still owe Leo a limited duty if Jeremy knew about the danger. New people might come near it and could reasonably be expected to do something to protect them. As the stories of the Wheat Hall accidents hit the news, a legal expert breaks it down. Lawful visitors are covered by the 1957 Act with a broader duty of care. Trespassers are covered by the 1984 Act, but only under limited specific conditions. Things like whether the risk was obvious, whether children were involved, and whether warning signs were clear. All matter. Learning from his mistakes, Jeremy puts up proper warning signs and repairs the broken fence. Leo now walks safely around the perimeter, smiling, headphones in, shortcut avoided. Under Section 2(4) of the 1957 Act, a sufficient warning can sometimes discharge the duty of care, but the sign must be clear and enough to allow the visitor to be reasonably safe. Let's pause for some special legal scenarios. First, what if an independent contractor gets hurt, like this electrician falling through the attic floor? If the danger came from specialist work and the occupier acted reasonably, they might not be liable. Second, children. A toddler in the kitchen opens a bottle of unlabeled cleaner. The law expects extra care where children are likely to visit. Kids don't spot dangers like adults do. And third, warning signs ignored. If a clear sign is posted and a visitor knowingly enters a danger zone, the occupier might raise the defense of valenti non fit injuria. You voluntarily accepted the risk. Back at the library, our law student highlights the key points in her tort textbook: lawful visitors and the 1957 Act, trespassers and the 1984 Act, duty of care, warnings, children, defences. The core of occupiers' liability is simple. If you control the space, you control the risk. And in the eyes of the law, how well you manage that risk might just determine who pays when things go wrong.